Welcome everybody to our afternoon session. I know that a lot of you have probably joined us for a few other webinars over the last 2 days, but just in case this is your first webinar, just to let you know that it will just be the speakers that you see today, not the other attendees. With a webinar, the attendee, your videos and microphones are disconnected. What that means is that any chat, any interaction, any questions that you might have, if I could ask if you could put that in the chat, that would be great. Or even just give us a shout out and say hello. We're happy to be interactive there. And we've got Cheryl and Heather behind the scenes who are going to be monitoring the chat. So any questions, please just pop them there and they'll highlight them to us during the session. And also just to highlight that the session has been recorded, really so that we can use it for training going forward, and also really just to keep it as a record of our conference. So really just to introduce the session this afternoon, for those that don't know me, my name's Donna Hegarty and I'm the Development Manager for Neighbourhood Networks. And I'm joined this afternoon by Claire and Kay, who are both from the Legal Services Agency. Now, both ourselves and the Legal Services Agency, we are lucky enough to be in receipt of funding this year from the Equalities and Human Rights Fund, which is a Scottish Government fund. And that has really allowed us to kind of know each other's organisation, find out more and look for opportunities to work together. And we've been doing some training and things internally with our staff. And this was also a great opportunity really to share with yourselves some information about the legal support that's out there to really just challenge any discrimination that might be happening and any support that you might need. So with that, I'm going to pass over to Kay in the first instance, and then Claire will be joining us later on in the presentation. So Kay, if I could pass to you, thank you.
Hello, sorry, muted again. Would have thought I'd learned by now. Hi, I'm Kay Fowkes. I'm a trainee solicitor at the Legal Services Agency, working on our disability and social justice project. And I'm just going to initially go through and explain about the Legal Services Agency and about the project. So, the Legal Services Agency is both a charity and a law centre. We're a law firm that works exclusively for the law firm and the lawyers of which work exclusively for the Legal Services Agency charity. And we were established in 1989 with a nationwide remit to provide advice and representation to people who may otherwise find it difficult to get that legal advice. We work both with individuals and groups, experiencing all forms of disadvantage, both looking at finding individual solutions for people, but also looking at opportunities to enact a wider sort of systemic change where we can do that. We have a lot of experience as an organisation in social welfare law, which allows us to develop and apply novel legal remedies that others may not think of. And we currently have offices in Glasgow and Inverclyde. And before the pandemic, we're holding outreach surgeries in Edinburgh and across other areas across Scotland. A lot of that's being done online now, though we do hope at some point to be doing those again. Though it's good that to be able to take advantage of all the online contact. It means people aren't having to travel all over as they used to. Okay. The vision and mission of the Legal Services Agency is, a vision is in a fair society where social justice is available to those who might otherwise find it difficult to access legal assistance. And we advocate for human rights and empowerment through sharing knowledge and promoting awareness of legal remedies in all communities. We're looking to be a legal we look to be a legal force in tackling inequality in our society and in our legal system. And the Legal Service Agency has been involved in some quite high-profile cases in a variety of the areas that we work, as well as looking at taking forward actions. We influence change by undertaking education, campaigning, and policy engagement. We're not simply, we don't simply do the legal side of it. We have a broader remit. And in doing this, our ethos is to, as much as possible, work in partnership with organisations with a broad remit themselves to try and create positive, sustainable results and about building a better future for all. So it's about the partnership, the work that we do, as well as that sort of more individual working. We work primarily in 6 areas of law. Most of our work is in housing, and we have a large team of housing and general court solicitors who, that's part of the team that myself and Claire fall under. They specialise in most areas of housing law, but it's also the more general social welfare issues. We also have a mental health team that are there to help providing specialised representation at mental health tribunals, helping people with things such as guardianships and powers of attorney where those are appropriate, and just helping people get through what can be a very difficult situation as easily as possible. We also have a criminal injuries department which advises people around criminal injuries compensation. So that's the Criminal Injuries Compensation Authority has a scheme whereby people who have been victims of crimes of violence can make applications for compensation. And that's something that we help people with navigating that. And again, that's an area that we've raised some quite high profile challenges and changed the law or the policy of that organisation, which has not only helped our clients, but helped the wider sort of people across the entire UK in making their claims. Working in employment, that's something that's always been part of the work that we do, but we also have a new employment project starting with the solicitor who's running that will be starting on Friday. And myself and Claire have got plenty of work for him already. So we'll see how long he lasts. No, not at all. It's just, it's an area that we do help. Obviously, there are lots of employment solicitors, but very often it can be hard for those with more complex claims to find someone to represent them. And particularly that can be people who have disability. It can be people with disabilities where it's been a long-term situation. It's not just been a single one-off event or a series of events that have led to someone's dismissal. It can be a lot more complicated and a lot more involved. In relation to benefits, we work with citizen advice bureaus and helping people when they're going to tribunals, giving that sort of representation, because being able to help them with applying for legal aid to obtain medical reports and advising on appeals and judicial reviews. So not doing that sort of first tier work, but we work in partnership with citizens advice bureaus where the advisors do that work and then refer on to us when it gets to a stage that they think we can help. And then last of all, we've got disability, which is the project that myself and Claire are employed on. And in that, we look to provide specialist legal advice, assistance and representation to disabled people throughout Scotland. Our project very specifically has a nationwide remit. Okay. Alongside that work that we do, we have a legal training department which specialises in providing accredited CPD in a wide variety of areas, not just the areas that we work in, but in almost any area. And Susan, who runs that, has a lot of contacts and can bring things that we've had things on areas that many of us would probably not have thought of ourselves, but they sort of pop up again, and that's sort of improving the broader education across for improving education across the legal profession, but also it's an area that we use to promote education in the areas that we specifically work in. So, okay, so to get to the Disability and Social Justice Project, as mentioned before, we are funded by the Equality and Human Rights Fund as the project that as Network, sorry, it's gone out. I've completely forgot. I know that I'm going to get it the wrong way around now that I've thought about it, as your own organisation is. And we've been funded to support and empower disabled people throughout Scotland to enforce their rights, challenge injustice, and reduce the day-to-day discrimination they face. And again, we're primarily based in Glasgow. That's where myself and Claire work, but we have a national remit, and we're looking to provide surgeries across the country in collaboration with disabled people's organisations. So that might be something that you may find yourselves may want to do at times. There may be situations where you would like to get us to come along and help with general advice also, rather with cases that might not need someone to take legal action, but someone might just want a little bit of advice on their rights. Sorry, someone just asked what does CPD stand for. That's continuing professional development. So that's particularly for those of us who are in regulated professions. We have to undertake a certain amount of accredited training every year so that we can maintain our professional status. So you'll find that teachers, doctors, accountants all have to do that sort of extra training. So unlike other people, the education doesn't stop once you finish university and go into a job. The way that the project works, a lot of our work is through access to legal advice. That's providing individuals with accessible and personalised specialised legal advice, advocacy and representation on breaches of equality and human rights law, but also helping people in a broad range of areas which might not specifically relate to a discrimination claim, but it can be that their disability for one reason or another makes it more challenging for them to access legal advice. So we are there to either help or to help signpost people to those who, well, should be able to help them. In addition to this, we've talked about this, we are doing our best to build close collaborative relationships with disabled people's organisations, which is part of what's led to us being here today. Providing training for frontline staff in recognising common forms of discrimination and building referral pathways to ensure early access to legal advice for disabled people. That being sort of having mentioned the employment context, very often when the cases get to us, they're incredibly complex, take a huge amount of work. Whereas if we'd maybe been able, if someone had known that they could come and talk to us earlier on in the process, we could have helped maybe at that stage. So by working with disabled people's organisations and giving some advice, we might be able to help people avoid having to go to an employment tribunal, because that sort of work, or going to an employment tribunal a bit earlier, rather than it all being dealt with at the last minute when we have time limits. And like employment tribunals notoriously only have a 3-month time limit from the last incident that you have to apply, which is actually not as much time as it might seem. And it's through working with disabled communities and disabled people organisation, we're wanting to help ensure that the service that we create is both accessible and intersectional. So we do have a lot of learning to do ourselves. So that's part of coming out and talking to people and learning and listening so that we can improve each time that we're out and presentation, and I've got a bit of hair that's flying around there. We're also going to be looking to raise awareness, and that's going to be done through analysing the casework that we undertake to identify key trends and issues faced by disabled people, and then sharing those findings across a variety of platforms with publications, online campaigns, web articles and seminars, looking to raise awareness across the general public and in the third, private and public sectors. And that's also something that hopefully will act as a resource for disabled communities to obtain information on their rights and how to challenge breaches of those rights. So it's getting the information out there. It's not just doing the cases and then not telling anyone about them. It's gathering that information and learning from it and sharing that learning experience. As well as individual cases, we keep an eye out for cases where there's an opportunity to engage in strategic litigation that's identifying a systemic problem and looking at are there cases that we can take further, potentially take to higher courts. And that also will look at finding people who are ready to go through that sort of process, because many people will just want to find a resolution to their own case. But then at other times you do find people who want to deal with that wider systemic issue. And it's sort of looking for those opportunities, if there is an opportunity to try and change policy within government organisations, within large organisations, and how they do that and how they interact, which will then improve the situation for a wider group of people, rather than just finding a solution for one person. And as part of the project, myself as trainee solicitor is going to be looking to doing research on the experience of those with hidden disabilities as to the barriers that they face in accessing legal advice and accessing the judicial system. Looking at, particularly for those with hidden disabilities, there can be additional challenges. One of the big ones being, as I'm sure many are aware, people don't always believe you when you say I'm disabled, and it's like, well, you don't look disabled. It's that sort of initial thing. It's that without having to go and educate people and do all this, and it's that additional stress that can be brought when you're just trying to access the system, which potentially will stop many people from accessing it. Something as simple, it's not simple, something such as dyslexia can increase the amount of time that it takes someone to read documents, to work through them, and then be able to respond to them, which brings up issues of time limits. And if the people that are being dealt with are not sympathetic to that, it can lead to greater problems down the line, with possibly people struggling in their cases because the judge is upset that they haven't been dealing with this, but doesn't understand the impact of their disability. So it's looking at that to sort of, again, develop this sort of wider change through the reporting in that. So the reason why we need networks, no one can be an expert at everything. Myself and Claire, I have lived experience. Claire's quite new to the world of disability discrimination, though she has a lot of experience in other areas of law and the areas of law that we work. So we've got a lot of learning. We still have a lot of learning to do ourselves, and we learn all the time talking to people. And it's only through doing that that we can improve ourselves, but also it's building up those connections so that we have access to people who are more expert than ourselves in other areas. We're never going to be able to learn everything, and sometimes we are going to have to be able to do that working in partnership. And the best data comes from people. It's only through connecting with other people and using the networks that we have that we're able to gather the broadest type of data, rather than individuals' opinions on what's happening. It's getting that lived experience from people is essential. And it's sharing information with people, because by sharing the information about the rights that people have, then they're able to enforce them. If you don't know that you've got these rights, there's no point really, because you don't know that you can enforce them. So it's that sharing that information with people so that they know they've got something to write and so that they can enforce, but also getting that knowledge of what people sometimes think are their rights aren't necessarily, that their understanding of the law isn't always that way. And that's where, again, no one can be an expert at everything, so people will need to come to us to explain sort of, well, no, this is what the law actually says and this is how it will work, and give that more realistic expectation, but also hopefully give people an understanding of an understanding of what rights they do have. So I think we're now, speaking of that, we're now over to Claire, who's going to do the more educational part of the presentation.
Thanks so much, Kay, and hi, good afternoon, everyone. I'm Claire, and I am the solicitor working on the Disability and Social Justice project. So what we thought would be helpful was to give you an overview of disability discrimination under the Equality Act, to help you to identify discrimination if you encounter it, or to be able to spot when somebody else in your own network might be being discriminated against. So you might be aware of the Equality Act already. This is the piece of legislation that protects people from discrimination, and it protects them from discrimination on the basis of 9 different protected characteristics, one of which is disability, which we'll be focusing on this afternoon. And it provides this protection by prohibiting certain people or organisations from carrying out different types of conduct. So it's useful just to make you aware that not everybody is bound by the Equality Act. But broadly speaking, it does apply to employers, anyone who's providing goods, facilities or services, anyone who is carrying out a public function, any education providers, and also associations, so like clubs that you might be able to join and that kind of thing. So there are 6 different types of conduct which are prohibited by the Equality Act in relation to disability specifically. And those are shown on screen at the moment. And I'll just take you through each of them one by one so we can discuss them in a bit more detail. And then we will move on to consider a couple of case studies and hopefully get a bit of a conversation going about those. So if we move on to the next slide, this is direct discrimination. This is the first form of discrimination dealt with under the Equality Act. And in a lot of ways, this is the most straightforward form of discrimination, and it's probably what most people think of when they think of discrimination. So direct discrimination is where somebody with a disability is treated less favourably than a non-disabled person would be treated, and the reason for the less favourable treatment is the disability. So it's important, if you're trying to argue that you have been directly discriminated against, it's important to identify a person who is a comparator. So this can be a real person or it can be a hypothetical person. But in either case, it has to be someone who does not have your disability, but who's the same as you in all other respects. And you have to be able to show that that real or hypothetical person would not be subjected to the less favourable treatment. And if you can show that, then you can basically show that the only reason you were treated less favourably is because of your disability. So examples of direct discrimination might include, say, a prospective employer withdrawing a job offer because they find out that the candidate has Tourette's syndrome, or a landlord refusing to lease a property to somebody because they have HIV. So these things are clear examples of unfavourable treatment because somebody has a disability. And if you can show that your disability was the reason for the less favourable treatment, then the person who discriminated against you has no defence because you cannot justify direct discrimination. So the next section is discrimination arising from disability. This is where somebody who has a disability is treated unfavourably because of something arising in consequence of their disability. So an example of this might be, say a tenant has autism, and because of that she makes a lot of noise in the property and the neighbours complain about it. So if her landlord tried to evict her from the property because of the noise complaints, this is something that might amount to discrimination arising from disability. So we can see it's not the same as direct discrimination, because the landlord might say, look, a non-disabled person making that amount of noise would be treated in the same way. I'm only treating you unfavourably because of the noise, it's not because you are disabled. But so long as the tenant can show that the reason she makes the noise is because of her disability, and if she can show that the landlord was aware that she has the disability, or that he should reasonably have been expected to be aware of that, then she can show that this is discrimination. So key points to note, as I said, the person discriminating does have to know about the disability in order to rely on this particular provision. We don't need a comparator for discrimination arising from disability, so we don't need to think about how a non-disabled person would be treated in the same circumstances. It is important to note, though, that discrimination arising from disability claim can be defended. So the person who's accused of discrimination can defend it on the basis that the way they acted was a proportionate means of achieving a legitimate aim. So there are circumstances where unfavourable treatment because of something arising in consequence of a disability can be justified. So the next section is indirect discrimination. So this is where there is a provision, criterion or practice, or a PCP for short, which is applied to everybody equally, but which in reality puts people with a disability at a particular disadvantage. So for indirect discrimination claims, we obviously have to look at the effect that a particular PCP has on the individual. But we also have to look at the effect it has on other people who also have the same disability as that individual. And we have to determine whether, as a group, people with that disability are put at a particular disadvantage compared to people who don't have that disability. So examples of indirect discrimination might include a letting agent having a no DSS policy. So this has been fairly common, particularly in the past. A letting agent might say that nobody who receives housing benefit or the housing element of universal credit is allowed to rent a property from them. So in theory, this is a PCP which applies to everybody equally regardless of their disability. But in reality, people who are disabled are more likely to be claiming these types of benefits than people who are not disabled. So the reality is that that provision puts people with a disability at a particular disadvantage and would be classed as indirect discrimination. Another typical example of indirect discrimination would be a restaurant with a no dogs policy. So again, this applies equally to everybody. Nobody is allowed to bring their dog to dinner with them. But in reality, if someone is blind and has a guide dog, then they will be particularly disadvantaged by this provision compared with people who simply want to take their pet to dinner with them. So again, similarly to discrimination arising from disability, there is a defence available to a claim of indirect discrimination if the person who's been discriminating against you can show that the conduct was a proportionate means of achieving a legitimate aim. Okay, so the duty to make reasonable adjustments. This arises where there's a PCP or a physical feature which puts a disabled person at a substantial disadvantage in comparison with people who are not disabled. And where this occurs, there is a duty to take such steps as it's reasonable to have to take to avoid the disadvantage. The duty also applies where a disabled person would be put at a disadvantage compared with non-disabled people unless they're provided with an auxiliary aid. And in that case, there is a duty to take such steps as it's reasonable to have to take to provide them with that auxiliary aid. So the way that this works is different depending on who we're dealing with. So what I mean by that is that service providers and public authorities have to make anticipatory reasonable adjustments. So they need to consider in advance what people with different types of disabilities might need in order to access their services. So this might involve, for example, a local authority making sure that any information leaflets they're producing are available in accessible formats. Or it could be a shop making sure that they have a ramp installed for wheelchair access. Or it could be, a bank installing an induction loop for people with hearing aids. There's loads of different anticipatory reasonable adjustments that can be put in place. The situation is different when we're talking about employment. So for employers, the duty to make reasonable adjustments is reactive. So it only arises in relation to a specific employee or a specific worker once the employer knows or reasonably ought to know that the worker has a disability. So for example, if a worker is blind, then the employer might be required, for example, to install a screen reader to help that particular person to carry out their work. But there wouldn't be a general duty on employers to make sure that they have screen readers there in case there is a blind person working for them at some point. So key points to note are that if you're under a duty to make reasonable adjustments, you cannot pass the cost of that onto the disabled person. You have to pay for the adjustments. In terms of a defence, if we're talking about the employment context, the employer might, and in our experience often does, try to argue that either the person didn't have a disability or that if they did, then they didn't know about it and they couldn't reasonably have been expected to know about it. Apart from that, there isn't really a defence, but you do have to show that the adjustment that you're asking for would be reasonable. And what is considered reasonable will be context specific. So there's a number of different factors that a court or tribunal will look at when they're deciding whether what you've suggested is reasonable. So they would generally be looking at, the extent to which the adjustment will remove or reduce the disadvantage. They'll be looking at how practical the adjustment is to make. They'll look at how affordable the adjustment is for the organisation. And of course, that depends on the resources of the particular organisation. And they'll also look at whether the adjustment could harm the health and safety of others. So the next type of discrimination is harassment. So under the Equality Act, harassment is unwanted conduct related to disability, which has the purpose or effect of violating a person's dignity or creating a hostile, degrading, humiliating, or offensive environment for them. So this is quite a broad definition, and it can encompass a really wide range of conduct. So it might be, for example, sorry, I've just noticed a question, a couple of questions. I'll pause and address these. So does that mean the onus is on the disabled employee to share information about their circumstances? Yeah, if you want a reasonable adjustment to be put in place, you would have to make your employer aware that you have a disability. The onus then shifts to the employer to make sure that they have put measures in place to enable you to carry out your job. But if the employer doesn't know that you have a disability, then you wouldn't be able to pursue that. Dyslexia, yep, dyslexia can certainly count as a disability under the Equality Act. So it certainly can fall within the definition. Really, you're looking at anything that has a substantial adverse effect on a person's ability to carry out normal day-to-day activities, which dyslexia can almost always be shown to have. So if you wanted your employer to make some form of adjustment to enable you to carry out your work with dyslexia, you would have to make them aware of that. Yeah, so Heather's saying that people may have a fear of sharing information about dyslexia. So we'll get on to the protections for that in a moment, but broadly speaking, the Equality Act does protect you if you've made a request for reasonable adjustments. It's illegal for your employer to subject you to any detriment for doing that. So if there were any negative consequences of you asking for reasonable adjustments, you would be able to bring a claim specific to that as well. Okay, I'll continue on. We'll get on to victimisation just in a wee moment, so we'll talk about that in a bit more detail. So harassment, as I was saying, there's a broad definition of what would amount to harassment. So it might include things like, a landlord making jokes about a tenant's disability. It could be someone who works in a shop complaining loudly about wheelchair users, or it might be an employer asking an employee personal and embarrassing questions about their disability. So, if that's something that would worry you about disclosing your disability to an employer, it's interesting to note that the harassment provisions do also provide a wee bit of protection here, because if you're treated in a way that creates sort of a hostile or offensive environment for you, then that is also unlawful. And I think it's really important to note that this is a subjective test. So even if your employer or whoever else isn't intending to be offensive, you're still protected even if you find the behaviour to be harmful or offensive. It's enough to show that that's the effect that it's had on you. And I think another interesting thing just to highlight about the definition of harassment is that it doesn't say that you have to have a disability to make a complaint of disability harassment. So the conduct has to be related to a disability, not necessarily your own disability. So again, this sort of broadens the range of circumstances where we're all protected by the Equality Act. So for example, you might hear your employer making jokes about people with learning disabilities. And it's perfectly legitimate for you to find that offensive, even if you yourself don't have a learning disability. And the Equality Act allows you to make a complaint if that is the case. So on to victimisation, which we have already touched on. So this is where somebody is subjected to a detriment because they've carried out a protected act, or it's believed that they've carried out a protected act, or it's believed that they might do so. And a protected act is basically doing anything under or in connection with the Equality Act. So, you know, that includes if you bring a claim under the Equality Act, if you make a request for reasonable adjustments under the Equality Act, if you support somebody else who's making a claim, if you give evidence in a court or tribunal, you can't be subjected to a detriment for doing that. Or if you yourself make a complaint, say in the workplace or at the bank or wherever it is that you've been discriminated against, you cannot be penalised for bringing that up. So yeah, a typical example might be if you do complain about disability harassment at work and your employer decides to fire you because they think this guy can't take a joke, he's obviously not fitting in here. You can bring a claim to the employment tribunal that you have been discriminated against. And you can do that even if you've only been working for the employer for a week. Usually to bring a claim for unfair dismissal, you would need to have been working for your employer for a period of 2 years, which means that a lot of the time people don't have any protection if they are dismissed. But if the reason for the dismissal was that you made a complaint that someone's breached the Equality Act, then you can still take that forward as a victimisation claim. So somebody is asking, reasonable adjustments is a subjective term, who decides what is reasonable? Which is such a good question. And you're absolutely right, it is subjective. So ultimately, if there is a dispute, it will be for a court or a tribunal to make the final judgment on what is reasonable. So this is something that comes up and that we do have to argue about in Kay and I's line of work. So, I mean, ultimately, you know, you make a request for reasonable adjustments, you put forward your case as to why it's reasonable for these adjustments to be put in place. You hope that the person you're asking agrees that they're reasonable, but if not, then ultimately your recourse would be to go to a court or an employment tribunal and let the judge decide what's reasonable in all of the circumstances. So if we move on now to, we've prepared a couple of case studies. So they're a bit lengthy and they're across 2 slides, but I'll just read them out and then we can have a bit of discussion, hopefully, about what types of discrimination are at play here. So case study 1, we have Jade, who works in a pub. So Jade has arthritis, which means that she's not able to change the kegs. Her colleague Marianne complains to a customer that she has to do all of the work because Jade can't lift the kegs, which makes Jade feel embarrassed. She tells the manager that she's upset about the way that Marianne spoke about her to the customer, and the manager tells Jade to go home early to cool off and warns her that she has to start pulling her weight. So a few weeks later, Jade is on shift again when the keg needs changed. She tells her colleague Jim that she's unable to do it, and Jim happily changes it for her, but the manager finds out and sacks her. So there's a few different types of discrimination here. if you would like to participate, if I could ask you to type a message into the chat and basically pick out which specific incidents you think are discriminatory here. Don't worry about picking what type of discrimination has occurred, although feel free to do so if you would like to have a go. I will give you a few minutes and hopefully we will get some responses.
Got people engaging their brains here, Claire.
Oh, could we go back to the first slide, Donna, if that's okay?
Yeah,
Possibly
sure.
easier if we take them one by one. We can come back to the second slide if we have some answers. Yeah. So Adrian has pointed out that Jade has a disability and a reasonable adjustment would be to have someone else change the kegs. So yeah, that's absolutely right. I think there's been a failure to make a reasonable adjustments here. It looks as though there's been a PCP that everyone who's on shift has to change the keg if it runs out, and it would have been reasonable to make an adjustment to that requirement and to have somebody else do it for Jade. Yeah, absolutely. So Heather said that the manager should have realised when Jade was employed that this may be challenging for her. So absolutely, depending on when she disclosed that she has arthritis, at that point the manager would be under an obligation to consider what reasonable adjustments might be needed for her. And certainly if the manager was aware of that, then he should have been at least speaking to her about this and putting those adjustments in place. Yes, so John has said that Marianne's complaint to the customer about Jade is discrimination, which is absolutely right. So I think that this would fall under harassment. So she's made comments which are related to Jade's disability, which has created a hostile, degrading, humiliating or offensive environment for her. Yep. So Kerry's pointed out warning Jade that she has to start pulling her weight. So yeah, I think there's a couple of things going on here. So you've got failure to make reasonable adjustments and potentially harassment as well, because that, you know, can only assume that that is not going to make Jade feel very good, and it probably creates an offensive environment for her as well, making a comment like that. Yeah, Jade was sent home for being annoyed about her colleague discussing her situation with a customer. Marianne should have been spoken to, not Jade. Yeah, so I think here we're looking at victimisation. So Jade has made a complaint that Marianne has been harassing her, and in response to making that complaint, she's been subjected to a detriment because she's been sent home from work. So absolutely, that would be victimisation. Yeah, and William said if Jade was forced to change the keg, she could injure herself or somebody else, which is absolutely true. There would be potential for a personal injury claim there. So, yeah, on to the second slide there. So Jade's on shift again, keg needs changed. Her colleague Jim does it for her, but the manager finds out and sacks her. Yeah, absolutely. Unfair dismissal. So if Jade has been working there for 2 years or more, she can claim unfair dismissal plus disability discrimination. Even if she hasn't been working there for 2 years, she can still put in a claim for disability discrimination. And so she can't claim unfair dismissal as such, but she can still put in a claim for loss of earnings resulting from the dismissal, and for compensation for injury to feelings as a result of the discrimination. Okay. Yeah, if somebody wants to help Jade, then Jade shouldn't be sacked because of that. Absolutely. So Jim took it upon himself to implement the reasonable adjustments for her, which is really as it should be. And yeah, the manager has clearly discriminated against her because of that, which I think would be discrimination arising from disability, because he's dismissed her because she's unable to do this particular task, and the reason she's unable to do it is because of her disability. Okay, thank you so much for your contributions there. We have a second case study now, which again is split over 2 slides. So I'll read through the full thing and then we can take it 1 slide at a time. So Mohammed has an appointment with his bank, and Mohammed is autistic. So this means that he's extremely anxious in social situations and he has an aversion to being touched. So his dad, Zahir, offers to come to the appointment with him. And Zahir is a wheelchair user. So Mohammed and Zahir need to get the bus to take them to the appointment. But when the bus arrives, there's no space for Zahir's wheelchair because there are prams in the wheelchair space. The bus driver refuses to ask any other passengers to move to let him on. And because Mohammed doesn't want to miss his appointment, he decides to get on the bus by himself without his dad. So on the next slide, we've got Mohammed becomes increasingly anxious by himself on the bus, and he goes into shutdown. So this means that he is unable to move and he ends up missing his stop. So the bus reaches the end of the route and the driver tries to eject him from the bus. But Mohammed, because he's in shutdown, he's unresponsive. So the bus driver phones the police and they physically restrain Mohammed. And this is extremely distressing for him. So his dad, Zahir, phones the bank to explain why Mohammed missed his appointment. And the woman at the bank says, well, that was a bit stupid of him, wasn't it? So again, a lot going on here. If we go back to the first slide so that you've got that in front of you, and if you want to pop your comments in the chat, that would be great. Yeah. So Adrian is saying that the bus driver had a duty to Mohammed, and if the space was allocated for wheelchair users, then it should have been vacated. So yeah, absolutely. I think that's the first thing to look at, was the actions of the bus company. So there have been a couple of cases about this, about specifically what obligations are on bus companies to get people to move out of the wheelchair space. The general rule which seems to have come out of these cases is that it would be reasonable for the bus driver to ask the person in the wheelchair space to move, and if necessary, and if there was time to do so, it would be reasonable for the bus driver to stop the bus in order to speak to the person who is occupying the wheelchair space and try and persuade them to move out of it. So it's clear here that the bus driver hasn't done enough, because he hasn't even asked the person who's sitting there to move. Yeah. Yeah, absolutely. Yeah, William's saying the bus driver could have asked the person to fold the pram and let the wheelchair user use that space. And Heather's saying a reasonable adjustment is to ask the pram owners to move their prams. I've been asked to do this many times when my children were young. Yeah. Okay. So if we go into the second slide now, can you see any discrimination here? What do you think? Yeah. So Kerry's saying that the bus driver calling the police was extremely drastic instead of considering why this young man was unresponsive. Yeah, so it may be that there would have been other steps that the bus driver could have taken to reasonably deal with this situation. And yes, so Williams mentioned the police, and Kerry's also said the police physically restraining a young man. So yeah, I think that the police here have failed to make reasonable adjustments in terms of their use of force. And given the circumstances, it would have been reasonable for them to use less force, and potentially to try to find some information or advice about what was happening and how best to deal with the situation, and looked at options to let Mohammed move on at his own pace. Yeah, absolutely. So the lady in the bank, Heather's saying that she's been very rude and lacked understanding. Adrian saying that this was not helpful and very disrespectful, very poor customer service. And Kerry says, I agree, the woman making comments about stupidity is terrible from a customer interacting role. Yeah, so in terms of that comment, I think that we would be looking at a harassment claim against the bank, because I think that this is conduct which is related to Mohammed's disability. She's commenting on an incident that occurred because of his disability, and if either Mohammed or Zahir can show that this comment created a hostile, degrading, humiliating or offensive environment from them, then the Equality Act would protect them in that circumstance. Yes, it is. Heather's saying the harassment claim is a very powerful tool, and I think it is, because it really does cover a lot of different situations which might otherwise, not fit neatly into a particular form of discrimination. Okay, so to round off, what to do if you think that you or somebody that you know has been discriminated against. If possible, it's so helpful if you can keep detailed notes of what's happened, including the date or dates of any incident. We would advise that you do make a complaint to the organisation or the body responsible for the discriminatory treatment. And above all, we would urge you to seek legal advice as soon as possible, particularly because there are really tight time limits for bringing a claim. As Kay had mentioned, if it's an employment tribunal claim, if it's an issue with employment, you've got 3 months from the date of discrimination to lodge your claim with the employment tribunal, which by the time you get an appointment with a solicitor and work through exactly what the claim is about, and perhaps have exchanged some correspondence back and forth with the employer, those 3 months are gone before you know it. And if it's any other type of discrimination claim, there's a 6-month time limit from the date of discrimination. So again, it's quite quick. So does anybody else, I'm aware of the time, I don't know if we've got time to go to questions, but so long as it's all right with Donna and Heather, if anyone does have any questions, then if you want to just pop them into the chat box.
Yeah, we've absolutely got time for a few questions. So just to say thank you so much for sharing that information. I suppose it's one thing that we hope we'll never have to use, but it's great to know that it's there, and a bit more understanding about how we can use those tools should they be required. So thank you so much for sharing that information.
I wasn't supposed to come on into this session. I'm supposed to be hiding in the background, but I've found it so interesting. And that harassment claim, you know, I've known for many years times of people having to put up with really appalling service, and knowing that the law is on your side to challenge that is really an eye-opener for me. So thank you.
So I think people have asked their questions during the case studies. So it's gone quiet now on the chat. So all that's left to say is thank you so much for joining us today. Really appreciate you sharing your knowledge there, Kay and Claire. And we now have your details should anybody unfortunately require any additional advice. So thank you. Just before I go, I'm sure one of my colleagues is putting up information about how to sign up for any more sessions that you're interested in tomorrow. We've got another 3 sessions. And then, more importantly, we have an after-conference party at 8 o'clock tomorrow night, where we've got live music and DJs until 11:30 tomorrow night. So please, if you haven't already signed up for that, please come along, sign up. Get in touch and come and join us for some informal fun. So thank you to everybody for joining us today. And with that, I'll say a final thanks to our speakers and wish you all the best. Thank you. Bye.
Thanks very much. Bye.
Thank you. Bye-bye.
Bye.